Hey everyone, have you ever wondered what happens if the original will of a dead person goes missing? Can a carbon copy or a photocopy of the will be used instead? Today we discuss the case of Lim Boon Ming and Tiang Choo Yang, a legal battle over a lost will, a family's inheritance, and the principles of law that determine the outcome. Our story begins in 1969 when the testator Lim Keng Hua, the person making the will, executed a will with the assistance of a lawyer. In that will, 30% of his estate was to go to his second wife, Tiang Choo Yang. 60% was to go to his son from his first marriage, Lim Boon Ming, the plaintiff. The remaining 10% was left to his adopted daughter, Jocelyn Lim. The original will was given to the testator, Lim Keng Hua, while the lawyer retained a signed carbon copy. They didn't have scanners in 1969. The will was designed to provide for his loved ones while ensuring that his son, as his direct heir, received the majority of the estate. Fast forward nearly 30 years. Lim Keng Hua died in 1998. But after extensive searches in his house, office, and other possible locations, the original will could not be found. His son, Lim Boon Ming, who stood to inherit 60% under the will, sought to admit the signed carbon copy for probate, while his stepmother, Tiang Choo Yang, opposed him, arguing that the testator must have destroyed the original will intentionally, thereby revoking it. This dispute created a significant legal question. If a will is missing, does the law assume that it was revoked? Two main legal questions emerged. Could the court presume that the testator had destroyed the original will with the intention to revoke it? This principle, known as animo revocandi, assumes that if a will was in the testator's possession but is missing after his death, he must have revoked it intentionally. If such a presumption existed, had it been rebutted by evidence? Was there sufficient proof that the testator still intended for the will to be valid even though the original will was missing? These questions had to be carefully examined by the court, as they had to determine whether the estate would be distributed according to the 1969 will or under the intestacy laws. Intestacy laws means dying without a will. As mentioned earlier, under the 1969 will, his son, Lim Boon Ming, would inherit 60% of the estate, while his second wife, Tiang, would inherit 30%. If the 1969 will was held to have been revoked by the testator, then the testator's estate would be distributed in accordance with intestacy laws, which means that the second wife, Tiang, would get 50%, and the remaining 50% will be divided equally to the two children. So Lim Boon Ming would have received 25% instead of 60%. The son, Lim Boon Ming, argued that the missing original will did not necessarily mean it had been revoked. He pointed to an event in January 1998, just months before his father's death, where the testator had shown a photocopy of the will to his brother. This was a clear indication that he still considered the will valid and had no intention of revoking it. The son therefore argued that the carbon copy of the will, signed by the testator and the two witnesses at the law firm, should be admitted for probate, as it was identical to the original and reflected the testator's wishes. Tiang, the stepmother, on the other hand, relied on a common law presumption. When a will is last known to be in the possession of a testator but cannot be found after death, the law presumed it was destroyed with the intention of revocation. She argued that the testator had ample time to change his mind, especially given his long illness before dying. Given the passage of time, his care under her, and changes in the family dynamics, he may have wanted to distribute his assets differently and revoke his previous will. She also pointed out that the testator had not informed her of the existence of the will, further supporting the idea that he may have revoked it long ago. After reviewing the evidence, the court ruled in favor of the son, Lim Boon Ming. The court acknowledged the presumption that a missing will is presumed to be destroyed animo revocandi. However, this presumption is rebuttable. It can be overturned if there is strong evidence that the testator still intended for the will to be effective. The January 1998 episode where the testator showed a photocopy of the will to his brother was crucial. It demonstrated that even months before his death, the testator still considered the will valid. Otherwise, why would he show a photocopy to the brother? There was also no evidence that he changed his mind after that episode. The testator was meticulous in his affairs, and while the original will was missing, it was just as possible that it was lost rather than destroyed. Given that the duplicate will was an exact copy of the original, the court found that it accurately represented the testator's wishes. Therefore, the presumption of destruction was rebutted, and the court allowed the carbon copy of the will to be admitted for probate. The stepmother's counterclaim for intestacy was dismissed. This case reminds us of the impermanence of material things, even the most carefully planned documents. A will, though meant to secure certainty, can vanish, leaving loved ones to battle in court. This mirrors a greater truth. All things change, and nothing is truly permanent. From a legal standpoint, the key lesson is to keep your original will in a safe, known place. Consider lodging it with a will storage service or give a duplicate original to your executor to prevent it from being lost. Always keep a signed original or a duplicate in case the original will goes missing. Inform your trusted beneficiaries about the existence and location of your will. If Lim Keng Hua had placed his will in a secure and accessible location, this case may never have gone to trial. This highlights the importance of preparing for the inevitable and ensuring that one's wishes are clear and legally protected. Thanks for joining me in this case summary. I'll see you in the next video.